Hi, good afternoon. Today is Thursday, January 19th. My name is Ashley Glover, and I'm here with attorney Kim Christian, and we are happy to welcome you to our webinar, New Year's Resolutions, Secure Your Future. So thank you all for joining us. Before we start, I do have a few quick housekeeping notes. This presentation is scheduled for 30 minutes. We have our webcams turned on, and you should also see the PowerPoint slides on your screen. To help minimize background noise, your mics are muted, so you'll want to use the Q&A box to submit any questions that you have. We are recording this, and we'll email you a link to the recording. And finally, please let us know how we did in the webinar survey. That survey will appear on your screen once the webinar ends. All right, so let's introduce our speaker, attorney Kim Christian. Kim is a dedicated partner at Russo Law Group. She's been with the firm for over 15 years and has helped hundreds of clients with elder law, special needs, estate and trust planning across Long Island. Kim's a member of several bar and board memberships like the National Academy of Elder Law Attorneys and the Academy of Special Needs Planners. She's also been recognized as a Super Lawyer Rising Star, and I am so happy that we have her on today. So Kim, I'm going to pass the mic on over to you. Take us from here.
Thank you, Ashley. Happy to be here. Welcome, everyone. Happy New Year. We're excited for our program today. What we will cover is separated into 3 categories: how to leave assets to family in a secure way, making sure the IRS doesn't inherit your assets, and protecting your assets if you need long-term care. I know for me, getting my planning in place is definitely, or at least reviewing my planning is definitely part of my New Year's resolution. All right, so for a little fun, we looked up what the top 5 New Year's resolutions were for 2023. Number 1, exercise more. Number 2, looks like it goes hand in hand, lose weight. Number 3, save more money, spend less money. Number 4, spend more time with family and friends. And number 5, look for a new job, pursue a career. So where does your estate plan fit in here? I noticed that it's not part of the top 5, although save more money, spend less money may fall into that category. So I did a separate list. It's called the Secure My Future list. And this should be part of your New Year's resolution. Update your will if you think it needs updating. Fill out a family tree. Have a family conversation about your estate planning, your decision making, what you would want to have happen if something were to happen to you medically. Who is going to help you with your finances? Create the asset and access list. Tell your loved ones, tell the people in charge of your estate, this is what I have. This is where you could get it if something were to happen. At the very least, tell them who your estate planning attorney is, right? We could talk about probate avoidance, long-term care protection, asset protection, and the all-encompassing completing your estate plan. I cannot emphasize enough how important it is to make sure that your estate plan is updated. So we're going to start with category 1. I call it how to leave assets to family in a secure way. How to leave assets to family in a secure way, common objectives of clients. So many of my clients come in and they say, look, way in the future when I'm not here anymore, I want to protect my beneficiary, my child, for example, from creditors if they have creditor problems. Or I want to protect them from marital problems. They can have the happiest marriage in the world, but statistically speaking, it may end up in a divorce. And you just want to make sure, hey, maybe I need to do something to protect those assets. I want to ensure assets pass to family with little or no delay or difficulty. You hear many, many estate planning stories where they say, wow, this estate has been tied up for years and the beneficiaries were unable to access things. So we just want to make sure they pass with little difficulty, little delay. You may want to protect your child who has special needs. It could be any beneficiary with special needs, but it is very important to make sure your plan addresses how assets will be left to that beneficiary. You certainly don't want to hurt any of the benefits they're on, and you want to maintain or create eligibility for them if in fact they need special programs. So those are my top three objectives that most clients have when they are doing their estate planning. So let's start with number one, how to leave assets to family in a secure way. All right, so there's a last will and testament, and your last will and testament is going to be a roadmap that allows for assets to pass very smoothly. It says, this is how I want things to go. For example, my children in equal shares. And then you can build upon it. You can do revocable trusts. You could do irrevocable trusts. What kind of trust you pick depends on what kind of objective you're trying to achieve. But just like the last will and testament, the revocable trust and the irrevocable trust will set forth terms, your plan, how you want things to go so that they're safely distributed to your beneficiaries. The terms provide for the beneficiary share. So for example, I could say to my children in equal shares outright, but I could also say, wait a minute, no, one of my children has special needs. I would like her share to go into a special needs trust or a supplemental needs trust. That is a way of protecting that beneficiary. I might also say, wait a minute, I am very concerned about my child's marriage. I want to make sure it's called separate property, or I'm very worried my child has had money issues, perhaps creditor problems. Is there a way I can make sure that those monies are protected for their quality of life and will last them for a very long time without any of the creditors attaching them? That would be called a family protection trust. So let's start with the family protection trust. That is often on many of my clients' minds. And what it does is it allows you to protect assets and income for your children and your grandchildren. It protects against creditors. It protects against bad marriages. It can save on estate taxes. We often joke around, we call it the parents' prenuptial agreement. If your child has not entered into a prenuptial agreement, but maybe you thought they should have, now's your chance to put those safeguards in place. And it avoids probate. It avoids the need for court involvement. So the Safe Trust is a planning tool that can be implemented, and your will can say, when I'm no longer here, I want my child's share to go into a trust for their benefit. It's not there to punish them, it's there to protect them. And we put safeguards in the trust to make sure that if there's ever a creditor issue, a lawsuit, a marriage issue, then the assets are protected and saved for their benefit. We're going to move to revocable trust. So we talked about the Safe Trust as a receptacle or to receive assets for a child in a protective way. But instead of a will or along with a will, you may choose to do a revocable trust. Why would I do that? That has to do with what we said. We want things to pass as smoothly and as quickly as possible. So if my assets are held in a revocable trust, they will avoid the need to go through what is called probate, the court process when I die. And that often will save time, it will save money, and it will allow pretty much immediate access to those assets. So what are some of the indicators when you would want to do a revocable trust? Well, if I had property in multiple states, I sure wouldn't want to be probating in all of those states. I'd want it to be in a private trust so that we can access it upon passing. Or you want family to have quick access to your assets. I hear that all the time. I don't want my family to have to wait. I've heard stories that it's stuck in probate and nobody can access these assets. If you place them in a revocable trust, then they will have immediate access to them. Or you have a family member who will likely challenge your estate plan. These are your assets until you pass away, and you have the right to leave them however you want. With that said, if you are going to leave a disproportionate share to one of your children, for example, or disinherit them for whatever reasons best known to you, you want to make sure that you minimize the ability for that beneficiary to challenge your estate. And one of the ways of doing that is funding a revocable trust and avoiding probate and court involvement. So these are some common situations that will help create a very smooth transition when you pass away and make sure that your estate planning goals are implemented. So now let's talk about the supplemental needs trust. So far we've talked about the SAFE trust. It protects children from creditors, lawsuits, marital issues. We talked about the revocable trust that allows us to avoid probate, give our family immediate access to the assets when we're not here. And we talked about the indicators as to why we would do a revocable trust. So now we're just going to touch on what's called the supplemental needs trust, a very important planning tool if you are leaving assets to a beneficiary with special needs. A supplemental needs trust is a trust where the parent provides for assets and income to supplement his or her child's needs. It protects assets from the government. It allows government benefits to be maintained, things such as Social Security income and Medicaid. So for example, if I have a child with disability, they may be receiving SSI or Medicaid or both. And we know that those are what's called means tested. If I were to receive inheritance in my name, I would actually lose those benefits and be penalized based on the assets in my name. So it is critical that if one of your beneficiaries is on a means tested program or may be in the future, that you consider putting it in a supplemental needs trust. What if your child has assets and they need immediate access to benefits? They need care, they need income, whatever the case may be. You might opt to do what's called a special needs trust. And a special needs trust passes and protects assets and income of a person who's disabled while accessing government benefits. So there is a distinction between the supplemental needs trust and the special needs trust. And it is important that when you're putting your estate planning in place, you identify what the appropriate trust is. Okay, so before I move on to making sure Uncle Sam, the IRS, doesn't inherit your assets, I know many people are interested in this. I just want to summarize what I said earlier. You just want to make sure that you update your estate plan. And if you haven't done your estate plan, put it in place, make sure the assets go to who you want it to go to and how you want it to go in the most protective fashion possible, if that is how you are feeling. All right, let's move on to taxes, right? We want to do our best to minimize or reduce or eliminate any sort of tax when you pass away. Common objectives of clients: save or eliminate what's called estate taxes, also known as death taxes. Did I die with too much money in my name and now the government wants to tax me on it? Right? We also want to structure our assets so we'll save the most on income taxes when the beneficiary is taking distributions from that asset. All right, save or eliminate estate taxes. So what is an estate tax? An estate tax is a tax that the government wants to tax you on if you have too much money in your name. They will add up your homes, they will add up your life insurance, they will add up your bank accounts, they will add up any asset that has value in your name and say, do they have too much money? Did they have too much money when they passed? And if they did, we're going to tax you on it. But they give you an exemption, they give you a credit. The federal government says an individual can pass away with $12,920,000 in their estate and not incur an estate tax. So that is times 2 if you are married. New York State says you have a $6,580,000 credit for each of you. So if you're married, that is 1 for each of you as well. So what you want to be doing is you want to be speaking to your estate planning attorney and saying, well, when I add everything up, does it look like I have an estate tax problem? And if I do, what should I be doing to address it? Because there certainly are strategies that can be done to make sure we eliminate or minimize estate taxes. So some of those strategies include the revocable living trust and last will and testament with the credit shelter trust. There also are an additional estate tax planning savings trust as well. So just to touch on the credit shelter trust, that is a trust that allows for the first spouse to make sure, the first spouse to pass away, to make sure to use their New York State estate tax exemption and possibly much of their federal exemption. So they are taking advantage of their credit and both spouses are passing as much estate tax-free as possible. Okay, so we talked a little bit about estate taxes. Those are what we call death taxes. Did I die with too much money in my name? And I definitely want to consult with my estate planning attorney to see if my assets are structured in the proper way and my legal documents reflect my ability to take advantage of those credits. Now we look at income taxes, right? So a general statement is that your inheritance will go income tax free. With that said, there are certain vehicles or accounts that, if withdrawn, are considered income to the beneficiary. So let's take an IRA, for example. If I have an IRA and I leave it to my daughter and my son, one of the things I want to do is I may want to leave it to them as an individual. Now, one size doesn't fit all. So if my child had special needs, I'd probably want to leave it in a secured special needs trust that also allows for a tax benefit. But assuming I was comfortable leaving my IRA to my child outright, I would want to name them as an individual, because they would be able to stretch that inherited IRA over a 10-year period and stretch out the income tax liability over those 10 years, as opposed to leaving it in a trust, because some trusts will result in a 5-year ability to stretch out the income tax. So as you can imagine, the more you stretch it out, the less of a burden it is, a tax liability all in 1 year. All right, so it's important to get the proper advice when it comes to IRA designations, because in the end, it may have significant income tax consequences. As another option is to do what's called a secure SNP. That is a secured special needs trust, because under the tax laws, there are certain exempt beneficiaries, such as a spouse or a disabled child, who has the ability to stretch it over their lifetime and get a better tax outcome. But you don't want to give it necessarily to that person outright, so you can do a special trust that not only protects the beneficiary's assets from a means-tested program standpoint, such as SSI or Medicaid, but it also gives them the same tax benefits as if you left them to an individual. So it is very, very important that when you're doing your estate plan, right, we see the big picture, we see what we call qualified assets, non-qualified assets, which ones are retirement accounts, and how best we should leave them. Another interesting part of income taxes is what's called capital gains tax. We want to make sure that when our beneficiaries inherit, they get what's called a step up in basis, right? And capital gains tax is a tax on the profit that is made on an asset. So if I bought a house, let's say for $100,000 and I sold it for $500,000, right? They would love to tax me on the $400,000 gain. But if I speak to my attorney and I make sure that the vehicle I choose for my planning has the ability for that property to get what's called a step up in basis, what I bought it for rises to the fair market value at my passing, that too may result or eliminate any sort of capital gains tax issue. Now, one size doesn't fit all. There are reasons why we wouldn't do it, but what you want to be doing is consulting with your estate planning attorney to make sure, do I need to do this? Is this appropriate for my plan? And is it in my documents? Very important, okay? All right, let's move to the third category, but as I always do, I just want to summarize, right? You just want to make sure when you're speaking to your estate planning attorney, you're addressing what's called estate taxes, also known as death taxes. Make sure that if you need to restructure assets to take advantage of those exemptions, you do so. You want to be talking about your retirement accounts, making sure that the beneficiary designations are appropriate so that we get the best outcome possible from a tax standpoint and also from a personal standpoint, making sure we protect people. And we want to be looking into our cost bases. We really want to be understanding what our capital gains tax may be looking like, and should we take any steps to address that as well. All right, let's talk about protecting your assets if you need long-term care. We certainly are covering a lot today. So many times I have clients come to me and they say, I am very concerned that one day I may need care at home, health care, or I may need a nursing home. And I want to make sure that I have protected and preserved my assets so that I can get the coverage I need, but I don't have to spend down everything I've worked so hard for. One example is a house. Many of my clients say, listen, I don't want a lien put on my house. I don't want to have to sell it. I want to make sure I've protected it in the best way possible. So how is long-term care paid for? We know in our area, long-term care is very expensive. Nursing homes are running approximately $15,000 a month. Home care is not far behind. If I have $30 an hour, 24 hours a day, 7 days a week, I am well over the $10,000 range. And long-term care can be paid for privately, but that is a lot of money to be paying privately. Some people have what's called long-term care insurance. That is insurance that covers their stay in a nursing facility or an aid at home, perhaps an assisted living. So if you have a long-term care insurance policy, you want to be making sure your attorney is reviewing that policy and making sure that it says what you think it says and it does what you think it does, because it is very critical if there ever is a crisis and you do need that care. Thirdly, it's the Medicaid system. And I say Medicaid with a D. And I say Medicaid with a D because I want to make a distinction between Medicaid with an R. Medicare with an R is the payer of short-term care. So many of my clients say to me, I'm not worried, I have Medicare. And Medicare is not for long-term care. It does not cover a nursing home. It will not cover home care on an extended period. So you want to be looking at Medicaid with a D. Okay, so Medicaid comes with rules and that comes with look back periods, right? If you say to a facility, a nursing home, I want you to cover me at $15,000 a month, You're going to say, hey, wait a minute, right? We're going to look back 5 years. It's called the 5-year look back. And we're going to see if you made any transfers out of your name. And if you did, we think you did it on purpose and we're going to penalize you, right? So the name of the game is really getting past that look back period. Home care, you have to have eligibility as well. While there's no 5-year look back for home care, you still cannot have too many assets in your name. So you want to start to protect them. You could protect your home. You could protect other real estate. You can protect certain non-retirement assets. And you would do this by setting up what's called the Medicaid Asset Protection Trust. That is an excellent option to protecting assets. It's a separate entity that you set up. You retitle your assets into the name of that trust. And now, for healthcare reasons, the assets are becoming more protected. You'd be able to access Medicaid for home care and nursing home care in the future. As I mentioned, there is a 5-year window. As far as the Medicaid Asset Protection Trust is concerned, your attorney can draft it so you keep the income, and it's like the same as it always was on your income tax return, so it's not a higher rate. You can protect your assets for you and your heirs. You can minimize taxes on the sale of a residence. You certainly can provide flexibility in it. It avoids probate. We talked about that earlier in the session. And it protects the assets from Medicaid and the nursing home. So if you are concerned that you may need care in the future, you certainly want to talk to your estate planning attorney about a Medicaid Asset Protection Trust. All trusts are not created equally. This is a very general seminar, so you want to make sure you drill down and you understand what your attorney is recommending for you, and make sure you're asking as many questions as possible. All right, so we're heading into the home stretch. I'm just going to summarize what I just said as far as protecting my assets for long-term care, right? I just want to make sure that I am doing everything I can so that if I need care in the future, whether it be at home or in a nursing home, my assets are secure. One of the ways you can do that is using a Medicaid Asset Protection Trust. So when and why should I update my estate plan? I say there's a rule of thumb. If you already have an estate plan, then it's about every 5 years, or if there's an occurrence of a marriage, a new child, a divorce, a major change in assets, retirement, a health diagnosis, or the death of a loved one. Those are triggering events that you should not wait to talk to your estate planning attorney. Now, as part of your New Year's resolution, if you don't have an estate plan, I think you should do it right away, if you can. And if you haven't had what I call an estate planning checkup in a while, I think that you should do that as well. It is very important to make sure you have your ducks in a row, as they say. All right, so I think I have 1 minute to spare. What should I do now? I should definitely create a plan. I should make sure all my legal documents are comprehensive. So make sure it says what you think it says and what you want it to say, and make sure that they're up to date. And you want to just get your plan implemented. Make sure that's part of your resolution. So I do see a question here, and I'm happy to take it. If you set up an irrevocable trust and your home is part of the assets, can you sell or buy real estate in that trust? So I'm going to give a general answer because, as I said, not all trusts are created equal, but the trust that I was speaking about, the answer is yes. It's wonderful. I can sell, for example, my home that I put in the trust. The proceeds from the sale can go back into the trust. And then let's say I want to downsize. I can purchase the new house from the trust. And now that new house has also gone along the look back period. So trusts can be very flexible. You certainly can buy and sell a house from a revocable trust and the Medicaid Asset Protection Trust as well.
All right, I'll jump in here and go ahead and close this up. We have reached 1:30. So what makes Russo Law Group different? Our clients tell us that it's our dedication, accessibility, scope of legal services, and the years of experience that gives them the peace of mind and confidence when working with us. We will not learn at your expense. This firm wrote the book on estate and elder law planning. We've helped over 17,000 families, and we build a relationship with our clients. We care about you, and we want to be your attorneys for life. Our firm has 11 attorneys, and we stand ready, willing, and able to step right in and help. We have 3 convenient office locations. We'll also make home visits and virtual appointments for you. So please, if you have any questions or need help with your estate plan, please give us a call. Here are the services we provide and how we can help you and your family. We have a robust website, vjrussolaw.com. We offer terrific information, forms, checklists, resources, so take advantage of it, please. It's there for you. In closing, we appreciate all of you for joining us. Please leave us your feedback in the post-webinar survey that will appear on your screen momentarily. And in case you missed any portion of today's webinar, we will email you a link to the recording. All right, Kim, thanks for your presentation. As always, it was wonderful. Thank you for being here. And
Oh, you're welcome. Thanks for having me, and thanks everyone for joining. Have a wonderful day. If you're anywhere near where I am, it's raining, but that's okay. We're gonna have a good day. All right, thanks for joining us.
thanks, Kim. Bye, everyone.